Welcome back to our podcast, Decoding Gaming Law. I'm your host, Franklin, and today we have a special edition podcast. We have with us Dr. Stefano Filletti, an expert criminal lawyer, and we'll be discussing and talking about financial crime, money laundering, and financing of terrorism, specifically throughout the court proceedings and also how it impacts gaming operators. Stefano, thank you so much for coming here. A brief introduction about yourself.
I've been working as a criminal lawyer for the past 25 years, and I must say I do enjoy it. I am currently the head of the Department of Criminal Law at University of Malta, and I'm also the managing partner of the firm Filletti Filletti Advocates. So that is basically my resume.
You don't need much of an introduction. You actually taught me at university for 2 years almost. So once again, thank you so much for being here. And we're going to jump right into the first question. So the topic of personal criminal liability. Why is it relevant for gaming executives? And what is driving recent case law and regulatory shifts at the moment in the Maltese scenario?
One of the basic misconceptions which gaming executives have is by shielding themselves from what they consider to be the corporate shield. It is a dangerous misconception that the fact alone that you act as a company officer, as a company director, means that insofar as mistakes are made within the company, it is the company which has a separate and legal distinct personality which will take the fall, which will take the brunt, which will take the fine. Shielding, they would believe, themselves from a personal capacity. That is not the case. There has been a sharp regulatory and legislative shift in the way of thinking, putting responsibility fairly and squarely, personally, on directors and gaming company executives in a myriad of scenarios. So we would find this responsibility when talking about money laundering, when speaking about data protection breaches, when speaking about consumer protection, player protection, compliance deficiencies, even under gaming rules. All these create personal responsibility for the company directors and executives. Why? It is accepted that when a breach is committed, when an offense is committed, the company does not have a will or a criminal intent of its own. So who has committed the crime? On paper, the company has, but the company is ultimately directed by its directors and executives. So the will, the desire, the intent to commit a crime, the negligence in committing a crime, and we'll come to that, is not a responsibility burdened to the company. Well, it shall. It shall also respond by way of fines. But the personal responsibility there falls squarely and squarely on the company directors and its executives. So yes, whether we speak about money laundering, data protection breaches, whether we speak about consumer protection and gaming unlicensed activities, aiding and abetting illegal gaming, the responsibility is shifting from the company to personal, individual responsibility of the directors and executives. So yes, today the gaming executives and directors need to be sensitive about this new reality.
So when you talk about personal responsibility and personal liability, are you saying that sort of the personal assets of the executives and the directors are at stake when a crime, such as the crime of money laundering, is committed?
That is correct. That is correct.
Omitted?
Yes, let me explain. So let's speak about the personal responsibility first, and then the consequence of this personal responsibility. So let's take, for instance, where one can identify a number of issues here and put them in hierarchical ground. I always say the most serious is money laundering, then comes data protection, then comes player protection, consumer rights, and compliance issues.
Yeah.
In that order, on the basis of severity of penalties. What is interesting to note is that the directors and executives have two issues here. The first is where they willfully, maliciously commit an offense. So they voluntarily and maliciously, intentionally allow the company to engage in illegal activities, illegal gaming, aiding or abetting gaming. They couldn't give two cahoots about data protection breaches, or actively engage in money laundering, either by closing one's eyes to KYC, etc., etc.,
Or financing of terrorism.
or financing of terrorism. That is one mode. But now, even there's a shift in the sense that gaming laws throughout the EU and the sixth anti-money laundering directive by the EU dictate that you can become personally responsible not only for what you commit, but also for what you fail to commit. And this is where the issue lies. You cannot, as a company director or executive, say, oh, well, yes, a crime was committed. I apologize. I had no idea that this was going on. My team did not report to me that there were these inconsistencies. I was unaware that we were engaged in these transactions, and therefore I can bear no responsibility because I did not know. The I don't know scenario means that you are negligent. The I don't know scenario is not a free jail or ticket to get out of jail free. No, on the contrary. Saying that makes you guilty of money laundering, because the legislation now requires you to take a proactive stance. It obliges you to ask the right questions, to escalate matters when there is a breach, to cooperate with regulatory authorities, to ensure your internal checks are robust, and to make sure that when there is an issue in your internal checks, that is addressed immediately.
So those are arguments of defense, so to say.
No. If you fail to show that you took proactive steps, assume there has been a breach, money laundering or regulatory breach. And as a director, you fail to show that you have taken, throughout the company's lifetime, a proactive stance, that you did everything in your power to know, that you did everything in your power to prevent these situations, you are guilty of the crime.
So there's no presumption of innocence.
There is, the burden is shifting, but not enough to say that you are presumed guilty.
Okay.
You still have a defense insofar as that you can prove that you've been proactive, that you've done everything you could reasonably as a director and company executive to prevent these crimes from happening. So today, being responsible personally for a crime doesn't mean only for what you have committed, but also for what you have failed to do. Your failure or oversight. Today, both gaming and money laundering and data protection, consumer protection and player protection all have an implicit duty of oversight imposed on its directors and executives. And that is an active obligation. Not knowing is not good enough. You have to know reasonably. You have to take proactive steps on a reasonable level.
Exactly.
And in any investigation, at least the ones I've assisted in, both from a regulatory point of view, as well as from a financial crime point of view, a lot of emphasis, both in Malta and abroad, this is cross-border, even if you see, for instance, the Gaming Commission in the UK, in its reports, they place heavy reliance and heavy importance and scrutiny on what the director and executive has done in his role. Has this director actively pursued robust compliance systems? Have they engaged in proper KYC, due diligence, transaction monitoring? Have they adopted strong policies for self-exclusion, vulnerable player protection, and the like? And where this is evident, because it is duly recorded, and therefore my advice would be to any director, company executive, that whatever measure he or she implements, it should be properly recorded in the acts of the company to show.
Through minutes, through board meetings,
Minutes, documents, memos, whatever, written instruction, whatever. That a proactive stance was taken, because that will save you. That will show that you have taken a proactive approach. And that is where you can defend yourself, saying, I was a director or company executive, but I took all these measures. So a failure is bound to happen. The question is whether you are reasonable in trying to prevent it or not. And authorities have, yes, protected directors who cooperated with them and who showed a willingness to cooperate and have shown have a track record of proactive engagement to prevent these sort of offences.
That's very interesting, and I think you sort of touched upon the question on best practices. So, as you mentioned, a few examples for a director to successfully avoid this kind of criminal liability is to have and record the implementation of policies and procedures, and through minutes, through resolutions, through memos, and all that. Can you mention, perhaps even through your experience during court proceedings, failures that have, so the opposite of best practices, where it's sort of this kind of failure will lead to criminal responsibility and liability upon the executives and the directors?
Yes. We want you to answer the responsibility and what punishment you are exposed to.
Yes, exactly.
However, when these investigations ultimately go to court, it is increasingly clear that the failure imputed on the company executive and company director personally now, we're not talking about criminal corporate liability, where the director sits for and on behalf of the company. We are speaking here where the director is sued, charged criminally for acts committed by his company under his direction.
It would be the public prosecutor.
Yes. In our case, yes, it would be the public prosecutor, it would be the Attorney General, the company prosecutor. In Malta, we have an Attorney General.
In our case, it's the Attorney General.
That is correct.
And they would sue together, so the director and
That is
the
correct
company.
too,
Okay.
because you have the company being responsible under the heading of criminal corporate liability. But you have an as accomplice or a co-accused, the director or the executive, in a personal capacity.
Okay.
And why would they do that? What is prosecution arguing? Prosecution is arguing that the director failed in his oversight obligation to prevent the commission of these crimes. For instance, the director failed to speak to his legal and compliance team. He had no idea what the legal and compliance team were doing. That matters were escalated to him or her, flagging issues, potential issues, and nothing is done. Being absent from the running of the company, allowing the company to flow into transactions which should never have happened. And I'm not speaking of wanton criminal offences where the director actually engages directly in these. I'm speaking of directors who close their eyes, shut their eyes to what they know. Why? Because to give an example, only in the realm of money laundering, the crime of money laundering is committed not only where you actively engage in money laundering or aid and abet money laundering,
Yes.
but where you should have known. And that means that the executive is being put in a situation where he should know.
And the comparability test. So the executive will be compared to an objective.
Now, how do you prove whether an executive or an officer should have known what he does not know?
Exactly.
And I refer back to the first part of this interview. I said the director and the executive has got to be proactive, ask questions, escalate issues, fix problems, ensure he's got a robust compliance issue, and record it.
Very easy.
So if none of these appear from company records, that he was never present, never took a proactive stance, never escalated, never asked questions, never asked for reports, never did anything, don't come and tell me you did not know. You did not ask. You did not seek.
Exactly.
You did not try to get to know. Just shut your eyes to the obvious. And that is not a defense. And you will be convicted. And this is why executives and company officers can land themselves into hot water.
Interesting. Very, very interesting.
This gets more complex. It's not necessarily scary stuff, and I will give my recommendations at the end. But one must also be very, very careful here. Another misconception which happens is when you have cross-border transactions, and in gaming it happens all the time.
Yes.
You are licensed in one country, but operate in a number of jurisdictions.
Yes.
When you have this cross-border transaction, as a director, that's why you should have a strong team, legal team, lawyers. I mean, we have our purposes. Compliance teams. Why? Because consumer law, money laundering, regulatory gaming issues can differ from country to country. Interpretations change from country to country. And if you're compliant in country A, that does not mean that you are necessarily compliant in country B and country C. And therefore, as an executive, you should know what the role demands from you. From a legal perspective, from a compliance perspective and regulatory perspective, from a licensing perspective, because there might be other conditions which you must fulfill from your license, from the license grantor, and from a cross-border perspective. So if there are peculiarities in country B and country C relating to money laundering, relating to player protection, consumer protection, or responsible gaming, you must comply also with those regulations in the other jurisdictions from which you operate, or in which you operate.
So for this cross-border element is very interesting and complicates matters even further. So if I get a request for information from the executive police in a foreign country, but I'm a Maltese gaming operator, should I cooperate anyway with the foreign request? Or should I tell them, listen, thank you, but please contact the local authorities and they will send me the request?
First thing you do is contact a lawyer, I would suggest. You've been contacted
Here you are.
by financial crimes. At this point in time, even within an EU structure, foreign investigative and judicial authorities still do not have the authority and the power to request legally, forcefully, information from you as a company under pain of sanction. So if you are licensed in Malta and operating from Malta, the only authority where you are obliged to cooperate with legally are the Maltese.
Yes.
And the foreign authorities could simply make a request to the local authorities, to the judicial local competent authority, to take action, to ask for information, to perform a search, whatever they need to do.
So we're ruling out extraterritorial.
Yes, but do you or do you not answer? This becomes quite interesting because in certain foreign jurisdictions, the moment in which the authorities are asking for information, and you fail to provide that information, you have not committed a legal irregularity. You have not committed a crime. You can't forcefully be requested to submit because there's no jurisdiction there. It's a question of sovereignty, of territorial sovereignty.
Yes.
However, I do understand that if you are operating in that jurisdiction, the same jurisdiction is asking information from you, it might not have the legal arm to force you to release the information, but there are other sanctions or other restrictions which they could do. They could make your life difficult to operate in that other jurisdiction. So one would need to assess legally, politically small p, whether it is desirous for the company to cooperate on a voluntary basis
Exactly.
or not. And there are circumstances where, yes, Maltese companies, to give an example from Malta, have cooperated with foreign authorities on a voluntary basis, and a good relationship was developed, and in others, the company decided to clam up. It all depends on the nature of the request, the type of the request, and whether the company operates from there to see the potential fallout in not cooperating.
Let's jump into the figures. So when we are talking about penalties, fines, imprisonment, punishment, whatever, what are we talking about?
So you have issues like player protection issues and data breaches, where you have fines which can run in tens of thousands of euros. When you speak of the big kid on the block, which is money laundering, there you have fines running into the hundreds of thousands. So it's not a trifle matter at all. Imprisonment. You would not get imprisonment for data protection breaches unless they are extremely serious and grave in certain jurisdictions. But for money laundering, you certainly do.
Even on if a director is convicted of negligence?
Negligence is an active crime.
Okay.
So shutting yourself to the obvious and allowing, in these cases, the ones we've had were millions, flowing through companies in and out, resulted in a very serious breach. So it is a crime of money laundering, because money laundering, for example, like in other kinds, has two modes of doing it: actively engaging or negligently allowing, as I explained, by shutting your eyes to the obvious and let things run on their own.
They're of the same
They're of the same gravity.
gravity.
They're of the same gravity.
Okay.
So where you breach your duty of oversight, there is imprisonment, which can go up quite substantially. 10, 15, 18 years.
Okay.
Not only in Malta, but across the EU, because the sixth anti-money laundering directive, the EU directive, also prospects and allows for jail term for active money laundering,
Yeah.
both in its wanton method or also due to negligence. And then there is obviously reputational damage.
Of course.
You are finished if you have charges of money laundering as a directive, or even serious data protection breach or serious regulatory breaches from a gaming perspective. Your reputation is tarnished. You become a high reputational risk person, and companies simply will not touch you. You will fail any due diligence exercise when you apply for a directorship, and even other financial institutions will have big issues to handle you.
Good luck opening a bank account.
For example, yes,
I
because
know.
you are high risk. And then there's also the civil side of things, where you can also additionally be held responsible of damages, because as a director and executive, you do have a duty, a fiduciary duty, to act in good faith, and that is owed to the company, to the UBO, to the shareholders of the company.
Safe to say the consequences are draconian. So
Yes.
it's good.
If you misbehave, yes.
Yes, it's good that you mentioned the best practices of how to avoid all of this. By way of concluding remarks, what advice would you give a newly appointed director at a gaming firm to shield themselves from future criminal exposure?
Now, let me be clear. This is not a situation of doom and gloom. And no way and means should one be afraid to become a director or executive, because if you hear what we've said, it's quite scary stuff.
Yes.
Doesn't have to be that way. But like in any other job, you have to be savvy. You have to know what you are doing. Therefore, as a newly appointed director, you have to take personal responsibility seriously. You have to own it, make it your own, and don't underestimate the pitfalls. So, appoint a strong compliance and legal team. Number 1. 2. Get advice on what you should be looking out for. What is this obligation of oversight? And in simple terms, what should I be looking out for? What jurisdictions am I operating from? So, in synthesis, what are my obligations for money laundering? As I said, consumer protection, responsible gaming in Malta, or in another jurisdiction I am working. That is your job. Adopt a procedure wherein you ask not once, regularly from your legal and compliance teams, updates, written reports. Ask questions as to what's going on. Are there any issues? Escalate matters when an issue arises. Fix immediately any vulnerabilities in your compliance strategy.
Yeah.
Tackle issues related to player protection, responsible gaming, because these are also monitored by certain countries like Sweden, Denmark, and the Netherlands.
Exactly.
They actively monitor these. And, as I said, record all your decisions and instruction. Because ultimately, when you are being investigated, what shall be under investigation is what information flows to you and what steps you have taken. The authorities never expect the unreasonable, but what is reasonable is expected out of you.
Yes.
And there have been many instances, many happy instances, where notwithstanding a crime has been committed, upon investigation it is clear that the directors acted responsibly, that the board of directors acted responsibly as a whole, and they were let off the hook with flying colors. So, insofar as you are vigilant, cautious, and proactive, you shall be fine. And if someone were to ask me, but does all this regulation stifle the operations of a company? Does it stifle the finance of the company? Does it stifle the growth of a company? Some would say the cost is high. But you cannot build a strong financial model on a company which will fall upon the first investigation.
Exactly.
So having a robust system will ensure longevity. And I believe that proper compliance goes hand in hand with healthy financial and economic growth in the company.
Thank you very much, Stefano, for that concluding remark. I think it was very, very interesting to look at this from a procedural point of view and court point of view, because we do have a lot of discussions on anti-money laundering and but this is more of a concrete example. So thank you for your time, and we look forward to welcome you again on our next episode. Thanks.